Choosing us to inform you on this 31st day of October 2024. We continue monitoring the developments that are set to play out at the corridors of justice, specifically Milimani Law Courts, where the three-judge bench led by Principal Judge Eric Ogola is set to give their ruling on the conservatory orders that were issued barring Professor Kithure Kindiki from being sworn in as a Deputy President of the Republic of Kenya. We expect that ruling to be handed over at around 2:30 p.m. and trust us to keep you updated as we dot the I's, cross the T's on the latest developments that are emanating from the corridors of justice. Remember, our team is already positioned on the ground to bring us up to speed with what transpires at Milimani Law Courts as it does. So we'll definitely keep you updated on what exactly will play out. Our reporter Grace Nganga, my colleague, will be joining us a little bit later on with more details on what to expect and equally thereafter on the ramifications that will follow that particular ruling by the three-judge bench. So a lot to talk about, so little time, and we are meant to sustain this conversation till around 2:30 and perhaps thereafter once the judgment is given. So do keep it right here for sober analysis, and as I engage legal minds in studio just to get their take on this issue that has put the country on tenterhooks for a couple of weeks now, ever since Rigathi Gachagua was impeached by the parliament. Thereafter, he rushed to courts and sought those conservatory orders, which are set to be canvassed today by the three-judge bench. A lot has played out in the corridors of justice, not just in terms of the conservatory orders, which will be ruled upon today. Equally, we saw members of the judge, or rather members of the legal fraternity, argue it out in terms of the public participation aspect, which was quite important during the impeachment proceedings at the National Assembly. Remember, the legal counsel representing the embattled Deputy President Rigathi Gachagua argued out that the public participation that preceded the impeachment motion at the National Assembly was insufficient, inadequate, and unjust. So we are set to canvass those issues. Not just that, equally the empanelment of the three-judge bench. Remember, Gachagua's legal team has headed to the Court of Appeal trying to challenge the empanelment of that three-judge bench by the Deputy Chief Justice, Philomena Mwilu. Remember, the Court of Appeal equally gave its decision today, not with finality rather, but they deferred the hearing at the Court of Appeal till around next week, if I'm not wrong, since some parties hadn't been filed. That's including IBC and whatnot. So we are set to canvass the issues around the verdict touching on the embattled, impeached Deputy President Rigathi Gachagua. But without further ado, I just want to cross over to my colleague who's joining us from Milimani Law Courts, Grace Nganga, who's set to give us an update on perhaps what to expect going forward in terms of this particular ruling that has weighty ramifications on the political lifeline of the embattled Deputy President Rigathi Gachagua, who was impeached by Parliament and thereafter went to the courts to challenge that particular decision. Grace, good afternoon. It's great to have you with us. It's quite a weighty day in Kenya's history, bearing in mind this is the first time we're seeing such proceedings touching on the person who's holding the Deputy President's position. Talk to us about some of the issues that are likely to play out in the course of this particular verdict as we reflect on some of the issues that played out in the course of this one-week case that was heard by the three-judge bench. Over to you, Grace.
Well, a very good afternoon to you, Jesse. Quite a big day today here at the Milimani Law Courts. It is a day that, of course, if I can say so, it's the D-Day for impeached Deputy President Rigathi Gachagua, as well as the DP-elect, that is Professor Abraham Kithure Kindiki, by the three-judge bench that is spearheaded by Eric Ogola, is set to make a ruling on whether the conservatory orders barring the swearing-in of Kithure Kindiki are going to be lifted or not. Quite a big moment there, as I said. For the last one day, that is because on Tuesday what we saw was a spirited battle fight between the lawyers of Gachagua and that of the state and that of Gachagua, who are calling for that particular judge bench to uplift those particular orders, claiming that is for the lawyers of the state, saying that there is a vacuum and they need that vacuum to be filled by that is Kindiki. But of course, the lawyers of Gachagua saying there is no vacuum. Gachagua is still the deputy president, and unless those particular orders are of course lifted. Quite a big day today, like I said earlier. And just to take you back to what happened at the Supreme Court, where they were supposed to give a ruling on the empanelment of the 3-judge bench by DCJ, that is Deputy Chief Justice Philomena Mwilu, but there was no order given. That case has been forwarded. It's going to be heard and determined in a later date. But if I can just mention to you, Jesse, unlike the earlier mornings when we came in, or in the afternoon when we came in, security has been beefed up outside the Milimani law courts. It's not as usual. We've seen police officers streaming in just to ensure that the security is tight. Here at the courts, what we are seeing is that the lawyers of Deputy President Rigathi Gachagua are in, as well as other lawyers of the state. That is what we're waiting for, as well as once the session starts at 2:30 p.m. Remember, this is a very landmarking ruling to determine whether that is Abraham Kithure Kindiki will be sworn in and become the 3rd deputy president under the 2010 constitution, or rather, if that is deputy president, impeached deputy president Rigathi Gachagua will also make history by becoming the shortest serving deputy president under the 2010 constitution. Like I said, quite a big day today. What we are waiting is for that landmark ruling that is expected to happen from 2:30 p.m. We are here, stand by, Jesse, and we're going to be bringing you events as they come throughout in the next 25 minutes or so here at the Milimani Law Courts. Jesse.
Crossing back to you a little bit later on, but thanks for that update, even as Kenyans are glazing into their camera screens or into their screens as the camera lenses are focused on the Milimani Law Courts, which will be hosting the verdict touching on the impeached Deputy President Rigathi Gachagua on whether those conservatory orders will be lifted or not. If they're lifted, we expect Professor Abraham Kithure Kindiki to be sworn in as soon as possible if the efficiency by the government in the last few days on this matter is anything to go by. So trust us to keep you updated on that particular ruling, and we'll be crossing over live a little bit later on at around 2:30 p.m. thereabout to get the very latest from the 3-judge bench. Allow me to introduce my panelists joining me in studio. I'm joined by Legal Minds. I'll first start with the entrant to the panel, Ishmael Nyaribo, who's an advocate, not a new face, not a new name to such panels. We appreciate your input and your presence right here. Karibu sana wakili.
Thank you, Rogers. Thank you.
Looking forward to your input. We're still joined by Manasseh, who has been quite patient. Manasseh, thank you so much for your time. He is an advocate as well of the High Court, and we had just engaged him a little bit earlier on during the 1 p.m. bulletin on a couple of issues. So Manasseh, it's great to have you with us still.
Thank you.
Okay, Nyaribo, as we welcome you to the discussion, I mean, it's a weighty day in Kenya's history. Legal jurisprudence will be set and whatnot. I think my first question would be, can a review of the conservatory orders prejudice Gachagua's rights? What's your take on that?
Yeah, definitely, definitely it will affect his rights. That's one, but it will also affect Kenyans' mood and feelings. It will also ruffle feathers with supporters of the deputy president. But primarily, I mean, Jesse, we always look at the bigger picture in your show. And the bigger picture here is there's democracy, being planted in our country strongly, being established. I mean, people can see that the deputy president can be impeached and there is no demonstrations, nothing big is happening. And I can assure you, even if this impeachment went ahead beyond this particular impeachment, let's say if it were to go to the office of the head of state, Kenyans have learned that we are happy people being peaceful. And that is a very important outcome from this impeachment. Okay. We will let it be fought in the courts. People can fight in the courts. A few people who are very close supporters can make a little bit of noise, but Kenyans finally are peaceful. So yes, a twist of the existing status quo by the High Court of Kenya definitely will affect the chances of the deputy president then moving forward with the energy, gusto, and the power he has as the deputy president.
Okay.
But let me tell you, this is only a fight in the High Court. We have a fight in the Court of Appeal. We have a fight in the Supreme Court. And the higher you go, the higher court can make any decisions they want to make. What is coming out today, Jesse, is the decisions the courts make should resonate with the public. I would tell you, in as much as all legalese can be used, the judgments the courts make should be, let's say, 70% acceptable by Kenyans. Never mind if 30% don't like a judgment, that's normal because a loser will always not like a judgment that says you are not right. But if the judgment is favorable among 20% parliament and executive, definitely people will always revolt. There are these legal principles that a bad law cannot be obeyed anyway by good citizens. Now these things come in. So I believe that yes, the ruling today will actually twist things in a certain way. And we are waiting to see that the ruling can resonate with the citizens. That's my prayer.
Well, it's very important, especially since the courts are a neutral arbiter. As you're coming, Manasseh, I'd like to evaluate the deputy president's or the embattled deputy president's options, especially in the corridors of justice. Because a little bit earlier on, we talked about the possibility of these cases dragging on for an eternity. What exactly are his options? What, as you look at his case and his legal counsel as they were arguing it out, what perhaps stood out as a silver bullet in terms of what Gachagua can pin his hopes on when it comes to winning this case at the corridors of justice?
Jesse, I think there could be two issues that the impeached deputy president was focusing on. Number one, it was the procedural inadequacies that were there at the National Assembly and at the Senate, because the arguments that were put forward by his advocates were that the procedure was unlawful, that the National Assembly together with the Senate did not follow the procedure provided by law and the Constitution in impeaching the deputy president. Number two, they talked about public participation. They said that the public participation that was carried out by the National Assembly was inadequate and that it did not meet the threshold capable for removal of a deputy president
What's that
from
threshold,
office.
if I may ask?
The threshold, I think if you had the Supreme Court the other day, I believe it was on Monday or Tuesday, the Supreme Court talked about the issue of the public participation. They said currently we do not have a standalone law that guides on how public participation should be carried. And they talked about that the public participation, as long as it can be shown that it has been done to a certain extent. First of all, the National Assembly cannot, let's say, give back views. Let's say you gave views to the National Assembly, you do, the Assembly do not have the right to return to you and say you gave us this and this and this, we have considered this and this. So as long as public participation has been conducted, that is seen to have been done. And I think the third thing that I had forgotten, the Deputy President said that he was not given a chance to be heard at the Senate, I believe. And that is one of these silver bullets that, you know, there are illegalities that were done because the rules of natural justice demands that you give someone a chance to be heard when there is a case against them. So I think those are among the issues that he raised, and those are the silver bullets.
You see, very important, actually, he talks about natural justice. If you look at the argument by the DP's lawyers, is that, I mean, the orders from Kerugoya are also orders from the High Court, isn't it? True. So why are they being brought and then fused into what's going on in Nairobi? So, and then the other side is saying that they don't understand how natural justice is implemented by removing an order from Kerugoya and then, you know, imposing it on a matter without them being heard. You know, all are arguing principles of natural justice. And that's what we are saying. So the Deputy President ought to be given hearing. So, you know, Jesse, we all know that Kindiki is a better fit. I mean, we've been arguing this even before elections and today. We have been arguing that the deputy president has actually made blunders through mouth whatever he has been. But when it comes to honest legal minds, where you see injustice, you don't shut up. You don't keep
Call it out.
So this particular process used to impeach the deputy president, we all know, I know personally, from little hearsay, that Rigathi Gachagua was supposed to go. But so don't put it in the public eye to see as if you are just using thorax, you are using power, you are using force, you are using disregard, you are using annoyance. No, you know, justice is never served that way. Justice means you let the natural process flow properly and then make your finding down there. There is no way I think that the deputy president was going to exonerate himself correctly of all the 11 allegations. So, and we know that even if one stands, he has to go home. But don't make it like a kangaroo court. Don't make it like these things happening at Jivanji Gardens and somebody's talking and another one is talking, and then you pronounce judgment there and then in Jivanji Gardens.
Yes, yes.
Senate of Kenya should be different from a kangaroo court. The National Assembly should be different. Our courts should be the last hope when we see injustice being done. And one more last point. When you look at people, you know, even legal minds are actually misleading the country. I have seen that in the courts, out of the courts. Very great minds are actually giving, you know, a skewed interpretation of the law just to fit a certain category of position. Because, no, look, why would you tell people that you cannot hear the president, the deputy president, because he has been impeached by a National Assembly and a Senate, when you know that under the Constitution of Kenya, Article 165 and several other articles, they vest their right to listen to any dispute in the High Court of Kenya. If you have a problem with your girlfriend or wife or child, it is still back to the High Court. If you have a problem with your brother at home and you don't agree mutually, traditionally, you have to go to the High Court. So this, you know, gerrymandering and intellectual manipulation, as I always say, of saying that a matter that has been decided in the National Assembly and the Senate under Article 95 cannot come to the courts of Kenya. That is utterly misleading Kenyans. The High Court can listen to any dispute, including if you say, I saw a bird, and another person is saying, I saw a snake. If you are smart enough and can couch that into a plaint, you can take it to the court and it has to listen to you. The duty to sit and listen to citizens. So I think we should not mislead Kenyans in terms of natural justice and whether the deputy president has been given that. And I say this with tremendous humility. It could involve me in the future, and I need natural justice. Well. It could involve today, it could involve Wetangula, by the way. It could involve Kindiki himself in the future. So I think setting a good standard and a good balance in law, it would actually help everybody.
It will definitely set the precedence. As you come in, Manasseh, I was listening to Gachagua's legal counsel, Ongoya, who questioned the hurried nomination of Kindiki as the deputy president and the subsequent National Assembly vote on October 18th, if I'm not wrong. He termed it as unprecedented. And I perhaps think he was poking holes into how a commissionerless IEBC clears a candidate. So can you poke holes into that super efficiency in obtaining clearances, especially in that letter by the president clearing Kindiki, yet Kenyans still wait for services, you know, ID, passport, you know, all those things. How do you look at it from a legal perspective?
Just you see, one thing that we must understand is that this is a political process. And I have tremendous respect for Ongoya. He's a great legal mind. And he questioned the time that was taken between impeaching the deputy president, the president nominating Kithure Kindiki professor, and parliament voting on nominating Kithure Kindiki. You know, the law provides for 14 days after an impeached deputy president, after the deputy president has been impeached, that the president shall nominate a candidate to fill that vacancy within 14 days. Thereafter, Parliament will vote on that within 60 days. But I wouldn't want to read into what was going on in the mind of the president, but I think his desire was to fill the gap or the vacancy as fast as possible. And this is a political process, and it is different from how we give services, because rendering services to wananchi is something that needs to be implemented in a long term. You know, once that service has been launched and you can do it as fast as possible, then the same way we are doing e-citizen right now.
Okay.
You renewing your license is not the same as you did 10, 20 years ago. So this is something that can be implemented. And I think rightfully the president was within time. It is only the reasoning behind it. But the law provides 14 days.
So commissionerless IBC can clear?
Not, and you had the arguments made by Somane.
Yes.
That number one, and I had these arguments also being put forward, that, you know, Kindiki, number one, was not a member of a political party, and so and so. And that Somane made an argument that such an appointment does not really need the person being nominated having been a member of a political party within 3 months. And I think that question of if IBC could have cleared him at night or not, I think that is among the questions that is being going to be answered by the courts.
Okay.
Yes.
Aye. So, Wakili Nyaribo, as you come in, I saw an interesting comment by a Kenyan, because currently as we speak, the president of the republic is outside the country. I think he's in Burundi. What happens in the unforeseen eventuality that, you know, he's indisposed? Who exactly takes over? Is it the speaker? Is it the nominated or the impeached deputy president? Well, what does the law say in such a scenario?
I actually got those questions right here in my, I was wondering why. So the thing is, let's be honest, that the deputy president of the country was impeached by the Senate and was also impeached by the National Assembly. But the logistical legal processes to kick him out of office have not been completed.
Okay.
To be honest, then the impeachment process is completed as per the National Assembly and the Senate. But the removal from office of the deputy president is what's going on. And it was caught midstream by these conservatory orders. They are supposed to then, of course, do the gazettement, which they did. Now, somebody's supposed to go to the High Court and question the gazettement itself. You know, Court of Appeal is considering some issues, High Court is considering some issues. So, yes, the National Assembly, the Senate are done. But then, is he in office? The answer is no. Has he been sworn in? The answer is no. There are certain steps that happen when the deputy or head of state has been impeached. Have those steps all been consummated? The answer is no. So I think that when you want to do, you know, political brainwashing so that your opponent shut up, you just say, no, we are done with this guy. Parliament, Senate is done. So, okay, fine. Now remove him from office. That is okay. It's heckling. It's political, you know, machinations you are trying to achieve.
Yeah.
But the moment this conservatory order is raised and Kindiki is sworn in, even if it is irregularly, then this deputy president will cease being deputy president. And now the argument will be, was the assumption to office, was it regular? There is an act for that. Was the, from impeachment to the logistics, you know, legal logistics used, were they regular? That will be issues for the courts to determine.
Okay.
But today you cannot say that we have two deputies, number one, and you cannot say that Rigathi Gachagua is not legally a deputy president of our republic. He is. But the deputy president in waiting, in my view, is waiting assumption. If you have not then taken oath of office, you cannot say you are a deputy president, legally speaking. But of course, politically speaking, to whip emotions and all that, then of course, you will see that we'll go there. And if I was not a lawyer, Jesse, if I was not neutral, if I was not impartial, to be honest with you, I could be making a lot of good noise for Kindiki as deputy president, because that is the only right thing for us to do at the moment. But you have got to have a bit of some decency in terms of what you learned in law school. So I cannot say we have two deputies and now what is the, you know, what is Rigathi doing? He should be away because we have two deputies. Which law will support that? In whichever way I twist it, no, there is no law that supports the fact that there are two deputies today. There is one deputy president and his name is Rigathi Gachagua. But the moment this order is removed, I am very sure everybody will be in a tie in the State House, and then they will install Kithure Kindiki. Then Rigathi Gachagua will not be the deputy president.
To add on, or to try and differ a little bit with what my senior Nyaribo is saying, you know, the reading of Article 145(7) says once the 2/3 majority has been attained, the holder of that office ceases to hold office. So that will be subject, because when he says the deputy president is still there, my understanding is that Rigathi Gachagua is no longer the deputy president. It is for the court to determine whether he will be back in office or not. And also, Kithure Kindiki is not the deputy president because the process of nominating him is not complete. He is not sworn in as the deputy president. And so, even Gachagua is not the deputy president. That is why he's still fighting to be there. And this interesting argument was raised by Professor Githu Muigai, because he argued that, you know, these are conservatory orders. What exactly is the court conserving? Because already the process of impeaching him is complete. We had begun the process, and an intervening factor has come in, and that is the nomination of Kithure Kindiki and passing of his name by Parliament. That is a further step into bringing Kithure Kindiki into the office. So my understanding is that Rigathi Gachagua is no longer the deputy president. Okay. And so Kithure Kindiki has not been sworn in as the deputy president.
Yeah.
Yes.
So who's in command right now that the president is not in the country, from where you sit?
The president has not left office. He's still in command from wherever he is. But if anything happens, I think it will be a very interesting scenario, because you had that issue being raised the other day, that what happens now that something happens to the president.
No, you know, you asked me that there, I think by, I just forgot to actually address that very briefly.
Yes.
You know, if it was like Uhuru's time, Sonko would have come on air and say, I'm the third in command. We don't have courageous politicians today who can come and say, by the way, the head of state went and he told me to be in charge. So shut up, you guys. So I think at the moment, to be honest, the president must have handed over power to somebody. Must have, by order or in writing or not, much as it's silent, must have said that in my absence, this will be taken over. And I think he must have given it to Kithure Kindiki.
Okay.
He must have told him, hey, look, we have all these issues, be in control. If not that, then he must have called on both the Chief Justice and the Speaker of the National Assembly to tell them that I will be away, but you know the order in terms of, in the unlikely events. Yes. So he cannot just take a flight and go. I mean, there's a whole country behind him. So he must have spoken to somebody, I'm sure, and alerted them that in my absence, ensure things are running.
Interesting. So, Nyaribo, I'd like your take on the possible outcomes of this particular verdict, because a little bit earlier on we were engaging with Manasseh on one of the possible outcomes being the court upholding the National Assembly preliminary objection on jurisdiction. The second would be the court assuming jurisdiction and lift those conservatory orders, or it could equally assume jurisdiction and refuse to lift these conservatory orders. What's the next step, bearing in mind the likely scenarios that might play out after this judgment?
You know, the court already said they cannot recuse themselves. So I don't foresee any pretense that they don't have jurisdiction to hear anything that comes before them. So they are really likely to say, we are here and the National Assembly has done its work and the Senate has done its work. And anybody who is aggrieved should not stop the process. They can always come to the courts. They can always go to the Court of Appeal and Supreme Court. But I think that Kenyans should not be impeded by a personal problem of the deputy president and the way he conducts his business with the head of state. So I think that the courts will also try to move away from any much interference, especially from what they have shown us. I mean, you can almost predict 90-95% that they are going to allow the impeachment process to go to fruition, to full fruition, to swearing in, and then if anybody is aggrieved, they will say there are always damages, there's room for compensation of any nature. So I tend to think that's one scenario. But remember, there's this matter in the Court of Appeal.
True.
So, and judges are so, I can say, different. I don't want to use the word flowers and it's understood. They come in various dimensions, shape, idea-wise. So you can be surprised. You can be surprised that even among these three judges, one might differ, so that the majority, carry the day.
Yes.
But also in the High Court, Court of Appeal, again, there might be two agreeing with the popular opinion, and if there are five, the three, reject, and therefore the majority carries the day. Okay. Same thing happens all the way to the Supreme Court. So, but what comes out is clearly, you cannot say, my brother, you cannot say that this impeachment is completed and there is a law that says so. This is something we are learning because it's the first time we'll go to the Court of Appeal, go to the Supreme Court, and then have what is considered the final jurisprudence. But even that final jurisprudence, to tell you the truth, will not resonate with the citizens. It will resonate well with the executive, with the State House. It may not resonate well with the people. So the final thing for people is just to learn to live with what State House wants, just like Raila has learned how to live with the governments, all governments. We should also learn to live with any government of the day.
Okay, interesting. And as you come in, Manasseh, I'm tempted to talk about this empanelment of the three-judge bench, but since it's in the Court of Appeal, sub judice and whatnot, let's talk about this issue about public participation, because it might be touched upon. As you earlier on hinted, Gachagua's legal team mentioned that this exercise, the public participation exercise, was insufficient, inadequate, and unjust. There's that ruling that says there's no law governing public participation. So if this particular court proceeding would poke holes into the procedural inadequacies, what's your take on how they would view this particular issue, bearing in mind the Supreme Court's decision earlier on and what we've seen in terms of argument? Yeah.
What I think, Jesse, will happen is, the Supreme Court has already pronounced itself on the issue of public participation, and I think this came in timely before the court went to write its ruling on this particular matter. Okay. So I believe that the High Court will be bound by the decision of the Supreme Court in how they coach or how they pronounce themselves in the issue of public participation. Okay. So I believe that is how they will try and maneuver on that issue of public participation. And if the High Court goes ahead and poke holes on the process and the procedure of the removal of the Deputy President, I think the consequences will be known. If the procedure was unlawful, the likely event is that the court will not uphold the decision of the Senate and the Senate and the National Assembly. Okay. Although, as I hinted to you earlier, is that, courts have tried to avoid interfering with political processes. And you saw this in the case of Kawira Mwangaza. And I think it began with the case of Wambora. That, you go to the High Court, you try and stop the process of impeachment in the High Court and the National Assembly. And the court said, these are institutions that are constitutionally mandated to carry on a certain process. And the courts are not allowed to interfere with that process until the end. And the courts will come in to question whether the process was lawful or not, and not to question the merits of that particular process. And that is what the courts have tried to do. That, the impeachment of the Deputy President, we will not touch on the 5 allegations or the 11 allegations that were there. We will only touch on the process and that were used in the removal, if the same was lawful or if it was unlawful. Yes.
And so, sorry, my brother,
yes.
Was it lawful and regular to leave out the Deputy President when he was in a hospital bed? I think that's a point. Once it's addressed by the High Court, then it can at least be moved to the Court of Appeal. And I think as citizens, we should not be so fixated about the impeachment itself per se, because it is done in Parliament. We should be worried about whether are the processes being used correct or wrong processes, legal or illegal processes. So for me, how would you leave a sick person in the hospital and then discuss him extensively? So that is what I think the court should be looking at. Number 2, you bring huge tons of evidence that have not been confirmed under the law of person safety and privacy. How have you obtained all these documents? Are they existing in public documents? Where did you get them? What is the source? Are you allowed to do that as Parliament? Those are some of the issues that actually I think would be, and those are the points. I don't think courts would be interested in saying, did you confirm that he actually disrespected the head of state? That is not for the court. That is left for Parliament. But how did you obtain this clip that says Kenya is a shareholding? I mean, did you follow the procedure? The answer might be yes. Okay, then how did you get this bank statement? If it is a process, the process used is correct, then of course the courts must approve. But if it is found that you, like you saw in the local daily the other day, you used somebody's phone to open a window in Android to drop into somebody's data without a court order, then of course it fails.
It's out, yeah.
And that is not a matter for the deputy president, but that is, it concerns everybody, including us.
Okay. That's noted. And as we can see on our screens, the court is almost filled to capacity, awaiting the arrival of Justices Eric Ogola, Anthony Mrima, and